Hello and welcome to the New Indian Express. On the 10th of July, the Supreme Court handed down a landmark judgment on Muslim women's maintenance. The fight between personal laws and general secular law has been going on for decades. The most famous example being the Shah Bano case of 1985. There are many aspects of Wednesday's multifaceted judgment that need explaining. To do that, we have with us the highly regarded Supreme Court lawyer Nipun Saxena. Let's hear from him.
Because it universally applies to all women, transcends any personal law. This particular case is, in fact, a culmination of something which started as long back as in the year 1980. Now, as we understand, Muslim marriage is a civil contract, that these two laws are complementary. So, this is a very harmonious interpretation in that sense to say, see, conflicts are always generated. Thank you so much, Alan, for having me.
Yeah, so without any further ado, I'll actually get down to the questions. Now, we have a landmark judgment in the field of maintenance laid down day before yesterday in the Supreme Court. So a lot of people out there are confused as to what does this actually mean? What does section 1, what is, or what does section 125 of the CRPC means or does for them? So could you please explain as to what this case is all about? What is the judgment? What does this mean for all the women in the country of India?
Right, Alan. So, as we understand, there are different faiths being professed by people in this country. Between two Hindus and between two Muslims or between two Christians, there are specific either legislations or customary laws which govern their marriages, maintenance, alimony, inheritance, adoptions, testamentary succession, and so on and so forth. Right? But there is this one particular provision which is secular provision in its outlook, because it universally applies to all women who are residing in India and claiming maintenance for either themselves or for their children. Right? Now, this particular provision, which is section 125 CRPC, transcends any personal law in the sense that while a woman, say, practicing a Hindu faith, may maintain an application under their own personal law, namely the Hindu Marriage Act, in addition thereto, she can also claim maintenance under section 125 of CRPC. Of course, the amount will be adjusted. That's a separate thing. But this particular provision, which is section 125 CRPC, applies uniformly and universally across all faiths. So that's very important. Now, if you look at one particular instance, this case, in fact, which is arisen today, there's a slight context to it. There's a background. This particular case is, in fact, a culmination of something which started as long back as in the year 1980, right? When there was no specific provision such as the Muslim Women Protection of Rights on Divorce Act of 1986 available. Right? So we are talking about a situation which is pre-1986. Until that time, Muslim women were only entitled, as per the Muslim personal law, of meher or dower, which was fixed at the time of marriage. Now, as we understand, Muslim marriage is a civil contract, unlike a Hindu marriage, which is divine sacrament. Right? Therefore, in the case of a divorce, a certain amount was fixed, which was called meher ki rakam or dower, right? And that was payable. A situation arose, and we had seen in a couple of instances that the amount which was fixed as dower, although with the consent of both parties, but that amount used to be very, very low. And that amount was not sufficient for the woman to maintain herself. And that is how the first case began, which was Shah Bano. In Shah Bano's case, an application under section 125 of CRPC was filed seeking maintenance on the ground that she is unable to maintain herself and therefore give us an amount. The husband, of course, challenged this, saying that whatever amount had to be given, I had already given it to you by way of that dower, or meher ki rakam, right? And therefore, I am not entitled to give you anything over and other about this. So the Supreme Court in Shah Banu's case held that this particular provision, which is section 125, is available to a Muslim woman to claim maintenance, notwithstanding any amount which has been paid in terms of the dower or the insufficiency of it, right? Now what has happened is that the parliament thereafter in the year 1986 amended the law recognizing that particular principle, saying that which is of course under section 3 and section 5 of the Muslim Women Protection of Rights on Divorce Act 1986, enabling such women to claim maintenance only under that personal law. That was the understanding. Now let's jump to this particular case. In this case, what happened was that there is an application which was preferred, saying that, look, if a section 125 CRPC application was preferred, in fact, that was challenged, saying that if a woman is entitled to, if a Muslim woman is entitled to seek any sort of maintenance, she can only do it under this particular law, which was enacted way back in 1986, namely that Muslim Women Protection of Rights on Divorce Act 1986. For a Muslim woman, she can only seek maintenance under that personal law, and that personal law, being a special law, will prevail over the general law, which is section 125 CRPC. That was the argument which was made before the court, right? So the issue before the court was whether in such a case that application under 125 has to be dismissed, or a woman, by virtue of being a woman and not professing a particular faith, can also make an application under section 125 CRPC. Otherwise, the result would have been that her 125 would have been dismissed and she would have to file it under the personal laws, right? So the Supreme Court analyzed the two laws and it said that these two laws are complementary because they operate in different fields. While this particular 1986 Act only applies to a situation where, let's say, dower has to be paid, or where, let's say, a woman is to be maintained only during the period of her iddat, which is the waiting period, right? However, section 125, there is no such restriction. In, again, another point of distinction that the court drew was that in the 1986, there is a specific time frame at which that particular provision gets triggered, which is if there is a divorce, then she will get the money. But under section 125, she has to prove that she is unable to maintain herself. And therefore, this operates in a different field altogether, right? So this is a very harmonious interpretation in that sense, to say that it is not which will prevail over which. It's a question where she is not paid sufficiently by way of, let's say, her dower or the meher ki rakam, then she is always entitled to claim money for the purposes of her or her children to be maintained under section 125 of the maintenance, right? And therefore there is no conflict as such. So that's in very
Yeah. So, but was there ever a conflict? Because people still contend that, this is an attack on the personal laws of this country, that the Muslim personal law is being attacked through section 125. Was there a conflict ever between these two laws in a legal sense?
See, conflicts are always generated. They are none that exists. If somebody were to say, just take another analogy, under section 24 of the Hindu Marriage Act, a Hindu woman is also entitled to seek maintenance under the HMA. However, that does not disentitle her to seek maintenance under section 125 CRPC as well. The only thing is that whatever amount is in excess would be set off. That's the general practice which courts follow, so that somebody does not doubly enrich themselves by filing one application under the personal law and another application under the CRPC. But question really is, can any woman professing any faith file a Section 125 application if she is unable to maintain herself? The answer is yes. And therefore,
Yes.
this law is a good law in that sense because it protects everybody, irrespective of the stage when that application could be filed, or irrespective of the status of the woman. So, just to give you an example, protect under the 1986 Act, a woman has to be divorced for her to be able to claim that amount. Now, suppose a woman is not divorced but she's estranged, then what does she do? She can't invoke this particular law of 1986. Then she
Yeah.
only will have to file a Section 125 CRPC,
Hmm.
where a man can always step in and say, but since we are governed under the personal laws, she has to wait. Right. So, in order to do away with all these difficulties, even in cases where there was, let's say, an estrangement not resulting into a divorce, or even if there's a divorce, Section 125 applies across stages. It does not require you to wait for an iddat period, only then make an application, right? So all that has to be proved for the purpose of Section 125 is that a woman is unable to maintain herself, and that's that.
Yes, but the defense, as I was reading the judgment, the defense at multiple stages they argued that the personal law in many stages they are much more considerate than Section 125 of the CRPC. For instance, one of the defenses I read was that the woman does not over here sufficient means is a very important word in Section 125 CRPC, where the woman must prove that she does not have sufficient means. But on the other hand, the personal Muslim personal law in the Shariat law, that is not required. So is it more considerate? Do you feel that the Shariat law is much more considerate than Section 125, the secular Section 125 CRPC?
See, the question is not about being considerate. You see,
Yes.
because this particular provision or the act itself triggers when she is divorced. The example that I just gave you, suppose she is not divorced, but she has just been thrown out of the house.
Okay.
Clearly, this act will not even apply to her.
Yes.
But does that mean that she will be left remediless? So the answer, therefore, is Section 125, therefore, saves these instances. It does not matter whether a woman can be living under the same roof and yet she can claim maintenance if the husband is not maintaining her. All that she has to prove, irrespective of her religion, caste, creed, or faith, that she is unable to maintain herself. She does not have sufficient resources to maintain herself.
Okay, now there was another doubt that kept creeping up was how is the quantum of the maintenance going to be decided? The amount, how will there be any changes in deciding that, or how is it actually going to be decided in a case? Yes.
Alan, there's no fixed formula to decide the quantum of maintenance in any case, right? There's no strict formula, unlike certain no-fault divorce states in the United States, where X percentage goes to the wife or Y percentage goes to the children. It is, I mean, of course, there are detailed affidavits of assets and liabilities which are to be filed by both the parties under Section 125, right? There are judgments of the Supreme Court which says that you have to do so. Neha versus Rajneesh is one of the most landmark judgments. It is only after both affidavits are filed, the parties lead evidence, thereafter a quantum is fixed. Even for the purpose of fixing interim maintenance, you have to first file those affidavits of income and assets and liabilities, right? It is only thereafter that through a judicial determination, after giving opportunity of both sides to argue a case, the court will come to the conclusion as to what quantum is to be given. And of course, that quantum differs from state to state. Perspectives differ. Are you living in a rural area? Are you living in an urban area? Whether the husband has other liabilities which would call upon bringing down of that amount, or of that amount being enhanced in any form, whether the education status of both the spouses is such that they are in a position to maintain themselves and not depend on each other. So there are so many considerations which go on. So just to summarize, there's no mathematical straitjacket formula through which you can fix some one or quantify maintenance.
Thank you, Nipun. Thank you so much for spending your time with us. You have really opened our eyes to a lot of things. Thank you. Thank you so much for spending your time with us.
Thank you so much, Alan. Thank you for having me. Thank you.